Good night, Professor Augusto. Good morning there. My name is Angie Santacruz, and I am going to be your interviewer. I am in first year at College of Law in Pontificia Universidad Católica del Ecuador, and we are grateful of your participation. Please welcome Augusto Zimmermann, Dean and Professor of Sheridan College of Law, PhD in Legal Philosophy at Monash University, Bachelor of Law and Master of Law at the Pontifical Catholic University of Rio de Janeiro. Professor Zimmermann is an internationally known legal scholar, a prolific writer and author of numerous articles and academic books, and is broadly recognized as one of the nation's strongest proponents of free speech. Thank you for your presence, Doctor. So first, can you tell us more about your academic background, please?
Yes, thanks, Angie. It's a pleasure to talk to you. I have been living here in Australia for 20 years now. As you say, I did my PhD at Monash University in Victoria. Then I was poached by the Dean of Murdoch University in Western Australia to work with him as an academic. I became a constitutional law professor at Murdoch University. And then after that, I was appointed to be what would be the equivalent of rector or reitor de pesquisas. So I did research. I became the research dean at Murdoch University. I also became director of postgraduate research. And meanwhile, producing books, articles, as your reference to me indicated, and that's actually what I have done over the years, producing books, especially in the area of constitutional law, freedoms in general. I am indeed regarded as one of the leading proponents of freedoms in general. I have a book on free speech that is quite well known here called No Offense Intended, which is basically to say that people are getting offended too easily and use the court system to be persecuting people on ideological grounds, which I find to be unacceptable and a violation of democracy. But another thing I have done is to become, and I was serving the government of Western Australia, appointed by the Attorney General to be Law Reform Commissioner. So I was the Law Reform Commissioner of Western Australia for 5 years, basically helping the government of Western Australia to produce good legislation and to enact good laws here in Western Australia. And it's wonderful to talk to you.
Thank you. And what about your previous experience in Brazil? Can you tell us more?
Yes, I did my Bachelor of Laws at the Pontifical Catholic University of Rio de Janeiro. Then I did my Masters of Laws at the same institution, but that was in the area of constitutional law and state theory of the state. And after that, I started being a professor in several institutions in Brazil. When I decided and I had published books there before I migrated to Australia to become an academic over here. I have a book called Curso de Direito Constitucional, which is a book of Brazilian constitutional law. About 4 years ago, I published a one-page book, 1,000 page, not one, 1,000 page, 2-volume collection on constitutional law in Brazil. It's called Direito Constitucional Brasileiro. And my first book is actually written in Portuguese, actually. It's called Teoria Geral do Federalismo Democrático, which is based very much on my master's thesis advocating for decentralization and advocating for better federal system. Not only in Brazil, but I became a federal theorist in many ways, and that became one of my main areas of law for many years. I got to be tired of federalism because I was always invited to talk on the same subject, and now I have moved forward to other topics that now excite me more.
Okay, thank you. Next one. We want to know more about your experience as a top academic and researcher in the fields of constitutional law and religion.
Yes, religion is an important matter, but when I have to say this matter of religion, I always take the perspective that religious freedom has to be taken to the context of freedoms in general. I would hate to see what the Muslims are trying to introduce in Australia, which is a form of Sharia law by stealth, restricting or limiting freedom of expression because they think that religionists and people of religion should be protected from criticism. My understanding of religious freedom is that religious freedom is important in the context of human rights in general. So I support religious freedom in the sense that I think that churches should have the right to express their opinions in according to their biblical values without being disturbed by the government. Another thing I have to bear in mind is that the churches have the right to freedom of association and freedom of assembly. So my approach to religious freedom is that it's a component of freedoms in general. And we have to take the human rights approach in these matters and certainly allow people of faith to have their opinions and to have their freedoms to proselytize. Another thing I do, obviously, is to support the idea of limited government, which is sometimes not very much supported, especially in Latin America, where people have a totalitarian inclinations. I think what we need for places like Latin America is to advocate for the rule of law, to advocate for a small government, limited government, individual rights and freedoms for all. Then we are going to have freedom and prosperity in Latin America. What hinders prosperity in Latin America is this totalitarian temptation of the elites who basically wish to grab more power in order to exercise this power over the people and the innocent citizens of this country. So I am an advocate for classical liberal approach to constitutional government, trying to enhance rights and freedoms as much as I can. And that's my whole fight for my whole life as an academic, to advocate for limited government, individual rights and freedoms, and responsible governance.
Okay, thank you. Next one. What do you consider to be the relevance for a constitution? Do you find it necessary to have written constitutions?
I think it's extremely necessary. England is a good example. I have a friend of mine called Peter Hitchens, and he is an excellent thinker in England. And he has written a book called The Abolition of Britain. And the reason as to why Britain is in such a big trouble is that they have lost their culture of legality and their appreciation for the rights and freedoms. I think an unwritten constitution depends on sociological underpinnings to make the constitution work. Because being unwritten, it means simply that some of the most important laws are not codified. So for instance, in England, we have important laws such as the Magna Carta, such as the Bill of Rights, being considered of such an importance that they are now considered to be of a constitutional nature. But the problem with unwritten constitutions is that it depends very much on the willingness of the people to make their rights and freedoms protected and respected. But once a country enters in a state of moral decay and cultural decay, this sociological protection will not necessarily help, even because people have started to forget their own heritage and forget their own traditions of the rule of law and protection of individual rights. And that's exactly what's happening. So I'm against an idea of an unwritten constitution. But on the other hand, I think a constitution needs to be well written and not be this piece of crap that we have in Brazil called the Constitution of Brazil, which looks more like a telephonic catalog of 1,000 pages. A constitution needs to be synthetic, can never be convoluted, and needs to be understood and loved by the people so that they can actually know in their own minds and their own hearts the rights and freedoms and establish the limits of state action as a result.
Okay, as you explained, you're against constitutions that are not written, but the next question is, what do you consider about constitutional system with no written constitution? Do you have any extra information to add?
Well, basically, these are different models of constitutionalism. A constitution might be apparently non-written, and that makes, legally speaking, this constitution a flexible document because there is not even a codification of the most important laws. But sociologically speaking, some models that are in theory more flexible, they can actually be more rigid because of the appreciation that the people will have to the most important aspects of their possible realization of the rule of law. I'll give you an example, for instance, of Brazil that has apparently a very rigid constitution, but because the country politically is very unstable, and the radical left is doing a very good job to destabilize, including the federal government, this very present moment, the constitution has to be constantly amended. And the constitution becoming constantly amended, even though apparently it would be a rigid document, in reality is far more flexible than many so-called flexible constitutions. So a constitution can be legally rigid, but sociologically flexible, whereas some constitutions that are apparently flexible are far more rigid than the so-called rigid constitution. So I think we have to take the holistic approach, because the realization of the rule of law is as much a social, cultural, and political achievement as it is a legal institutional one. A good example is that the Constitution of Australia talks about the role of the Governor General. I would never export the Constitution of Australia to Brazil, or even to Ecuador, or even to any other country, because the powers there granted to the Governor General are too broad and too big. The only reason as to why the Governor General doesn't become a dictator is because we have the constitutional monarchy and our Westminster traditions that make the role of the Governor General to be exercised according to unwritten rules, rules that are derived from our history and our tradition of Westminster parliamentary system. So that we have to take into account that the underpinnings of an unwritten constitution are derived from this sort of tradition that must be respected in accordance with the common law system that we have inherited from England originally.
Okay, thank you. Next one. In your opinion, what are the most significant changes and advances in the constitutional law field?
I think we don't have so many advances, but actually we have the opposite taking place. Unfortunately, we tend in Latin America to copy decadent approaches, especially the ones now being adopted by the Supreme Court of the United States. But you have to bear in mind that these approaches, such as the so-called living constitutionalism, is leading to the erosion of the rule of law in America. And certainly the United States of America is a good example of a country that should not be emulated at this present moment. The Supreme Court of the United States has a tendency to legislate from the bench. And as a result, some Supreme Courts in Latin America are copying a model that's doomed to failure because it undermines the principle of separation of powers, it corrupts democracy, and it further empowers illegitimately unelected judges who don't have the necessary level of democratic legitimacy. A good example of that is, for instance, Obergefell, the same-sex marriage decision in America is a good example. Regardless of one thinks of what one thinks on this issue of same-sex marriage, I think everybody should support the idea of respecting the written constitution. I think everybody should respect the principle of democracy. And this decision violated democracy, violated the will of the people, violated federalism, because this area in family law issues in general belong to the American states and not to the American federal government. So what we have in this situation is actually a destruction of the federal system and the principles of democracy and accountability of government. But to make it even worse, they claim to be gods because they dare to say that they can create fundamental rights. That destroys the American model, because the American model believed that rights are inalienable of the individual. You can create certain privilege, but you can never create a fundamental right, because a fundamental right is not given by government. It's actually belonging to you as an individual from the very beginning. That's why the American founders called this inalienable. Once the Supreme Court of the United States corrupts this idea and claim that they can create fundamental rights, they actually claim to be more than just a human being. They claim to have the powers of deity, because these rights were considered to be inalienable and God-given and not given by the state. If the state gives rights, the state can take away. And so let's bless the name of the state. I don't like that. I think we should not give so much power to these authorities. Powers should not be given in such a manner. But I have written many articles about this, and I can entertain your people later on, sending what I have produced on the subject.
Thank you very much. It's very interesting. And finally, the last question. For an emerging and transitioning economy like the Ecuadorian, what would be your general recommendation about constitutional reforms?
Well, certainly what you need to do is to make sure that the Constitution of Ecuador follows a model where the norms to be contained in the document, in the Constitution itself, are materially constitutional nature. And anything that is actually derived from unnecessary principles and conditions should be transferred to infra-constitutional norms or legislation. I think we should make the Constitution simple. I think we need to force the authorities to abide to these rules. We desperately need to have the principles of the rule of law respected. I wrote a PhD thesis on the rule of law, and I think few people know more on the subject than me. The president of the American Bar Association invited me to write a special chapter on the rule of law for them, for the Americans. And what I have to say about the rule of law is that it demands legal certainty, it demands judicial neutrality, it requires that the laws can be predictable even in the long term. If the laws change too much and the parliament is too active, that leads to less rule of law. Why? Because the citizens are not allowed to plan their lives according to predictable rules. If the rules change all the time, it's almost like not having them. It's like playing a game. Let's say that I'm playing Monopoly with you. And every turn of the game, I change everything according to my will. So, of course, this is completely unfair. And that destroys the economy. So what Latin America needs to have economic prosperity and freedom is to have the rule of law. And to have the rule of law, the rules need to be predictable. You have to plan your life according to these rules. You need to have legal certainty. You need to have judicial impartiality and neutrality, and certainly avoid judicial activism, because that undermines the principle of separation of powers and undermines precedents and undermines stare decisis that's so important for the realization of the rule of law. So all these things are not difficult to be achieved. Perhaps there is a more sinister agenda that prevents it to happen, because some ruling groups, the ruling elites, actually profit at the misery of the people in general in Latin America. What you need to do is to realize that the socialist idea of a big government only favors those who have access to this power at the expense of the people in general who want to prosper, who need to have stable rules, and to need to have the protection of their individual rights and freedoms respected by the law and obeyed by the government.
Okay, thank you very much, Professor, for your interest in this interview, and of course for sharing all your knowledge to all the community of students. I hope to hear more about your work, and thank you very much for participating.
Thank you very much, and God bless you and your people. And my heart and my mind and my heart goes to you and to the people of Ecuador. And I hope that what I have said to you will be profitable and I hope to keep in touch with you in the future. Thank you very much for talking to me.
Thank you too. See you soon.
See you soon. Bye-bye.
Bye. Thank you.